So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about the federal court striking down California's unconstitutional board diversity statute, which was pushing towards representing underrepresented communities in the boardroom. So a little bit background on this. There was AB 979, and AB 979 requires that no later than the close of 2021 calendar year, quote, a corporation located with a principal executive office located in California must have at least one director from an underrepresented community, and then down the line it would require more. Now, an underrepresented community, for the purposes of this act, was from the law itself, means an individual who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as gay, lesbian, bisexual, or transgender. So I think that's very unique. There are a lot of underrepresented communities in the boardroom, and it could be really easy to, for example, use the EEOC's definitions of protected classes, which generally speaking also reference underrepresented communities, and use that as a sort of a better defining line. I still don't think that this would be successful, but at least it would be a consistent thing, right? Protected classes like disability are very much a very important piece to making sure that people are represented in the boardroom. In addition, there was SB 826, which held that under the same employers, people who have execution and filing of articles of incorporation with the Secretary of State, and who have an principal executive office in the state of California, must have at least one female in the board of directors by the end of 2019, and that would increase depending on the size, et cetera. And so that was SB 826. There's been a lot of challenges to SB 826 and AB 979. The assembly bills in California are really where things get a little bit crazy. I've seen some wild assembly bills. This one just seems very poorly defined and poorly articulated. There's potentially ways to encourage things like this, but I don't know that this bill makes sense. So there was an important one filed for the Alliance for Fair Board Recruitment versus Weber, which is in the U.S. District Court for the Eastern District of California, and they granted the plaintiff's motion for summary judgment, which this Eastern District Court said that AB 979 was unconstitutional on its face. I think that the legal term is prima facie. I am not a lawyer, guys, and I want to make that clear. Don't even play one on TV. But in Alliance, they maintain that states may not require discrimination on the basis of race without making a convincing showing at the outset that the discrimination is narrowly tailored to advance a compelling state interest. And then further, they allege that the law is, quote, unconstitutional and patronizing social engineering, and it's focusing on perpetuating invidious racial categories. In addition, it doesn't, according to the plaintiff, claim to remedy any particular past discrimination. And so, in addition, that it's a violation of the 14th Amendment, which is a prohibition against discrimination based on race or ethnicity. And as a result, it's unconstitutional. The court granted the plaintiff's motion, concluding that the plaintiff's challenge to AB 979 is affirmed, and that AB 979 constitutes a racial classification that is permissible because it was designed to remedy past discrimination. I don't understand how the secretary makes this argument, but the court rejected the secretary's semantic argument and said because it wasn't effective. It's a race-based quota as defined by the Supreme Court, and as a result, creating these quotas, it's unconstitutional. And it's unconstitutional on its face per the court. And so it's very clear. I mean, when this was put into effect, it was not going to survive any sort of constitutional challenges. I think anyone who was, basically understanding of the law knew that would that it wouldn't survive because it's, effectively a racist law, right? It's putting quotas into place that are unacceptable in a modern liberal democracy. And so you see this. Should companies employ greater diversity in its boardrooms? Yes, absolutely. It must create pipelines to create greater diversity. Does the force of law by categorizing people into specific groups that can be easily manipulated? I, you know, I, I mean, I think it would be just awful. I mean, two things, right? So one, you would undoubtedly have someone who declare that they're part of an underrepresented community, and that would potentially cause all sorts of blowback, both within the organization and outside. And two, it would probably make people feel otherized who did take the role, right? It would create the idea that they only got the role because they were a member of the underrepresented community and not because they're a great worker and competent at their job and so forth. And that's really the shame, right? It takes away the pride of achievement, or could take away the pride of achievement, because you're complying with California's laws. And I think that that's the real shame, in my opinion. Let me know what you think in the comments down below. I'm curious what my viewers think about this, and we'll see you on the next video. Bye, guys.